right now, I'd like to introduce our managing partner over at the Orlando office of K. Bender Rembaum over in Central Florida. Very popular, keeps this stuff from being the cure for insomnia. He keeps this stuff interesting. Alan Schwartzseid from Orlando. Alan, please take it away, and I'm going to do as little talking as possible today.
Thanks, Jeff. And I'm going to ask you, just as a courtesy to me, to stop building unreasonable expectations because this stuff is not exciting, but I'm going to do my best anyway. And one thing that I'll ask, and I'm sure that there will be people that jump on a little later and won't heed this request, please don't email me asking for the slides or your certificate during the webinar. Just at least wait until after we're done. Because inevitably during every single webinar I do, I get at least 1 or 2 emails when I'm not even done presenting yet asking where a certificate is. Jeff's going to explain how to handle all that. So with that out of the way, thank you for attending. This is the 2024 legislative update. I will throw in a couple tidbits here and there regarding the upcoming changes that haven't hit yet. But the main focus of this, just so that we're clear, is the legislation that changed in 2023 and is now 99.9%, if not all, already in effect. So this is law that you should already know about because it's already happening. As Jeff mentioned, I am the managing partner of K. Bender Rembaum's Orlando office. Just so that you know a little bit about the firm, if you're not one of our regulars, we do have offices in Pompano Beach, Palm Beach County, and Palm Beach Gardens, as well as Tampa and in Miami by appointment. I usually say we've got 21 attorneys. We've now got 22 because fortunately, we just had an attorney join our Orlando office. And so now we have 22 attorneys. All we do as a firm is represent community associations and deal with the issues that communities have. So if you're on your board of directors, you either don't have counsel, you don't like your attorney, or frankly, you're just not getting a response in a timely manner, please feel free to reach out. My email is going to be on the slides that usually I would have already put up, but I'm going to do that now. So, I really do genuinely welcome you to reach out. We routinely field questions, and our goal is not just to provide the education during these courses, but to be a resource, both with these courses that are available online, that are taught for CE credit for managers, that are taught for board certification, but also the articles that several of our attorneys write. All of this you can find at our website at kbrlegal.com. We don't charge for any of it. We just want to educate people to the extent possible. But we're going to move a little fast. I do have 89 slides. Fortunately, we've got some time to go through them. And we thank you for showing up. We do really focus on this area of law. 8 of our attorneys, I think possibly 9 now, are board certified in community association law. We've also got someone, we'll talk about construction issues today. We do have someone that is board certified and very well versed in construction law and construction litigation. So we try to be a one-stop shop for community associations. We're not that, if you come in the door with business, we'll take it type of law firm. We're very specific as to we represent community associations in Florida. Occasionally, very rarely, will we assist anyone else, and it's almost always going to pertain to community associations. So we've got about an hour and a half to cover another 88 slides. So let's go ahead and get started. First bill that we're going to talk about today is Senate Bill 154. This passed. It pertains to milestone inspections and other mandatory structural inspections. This is specific to condos and co-ops. So if you're in an HOA, I understand that this might be a little frustrating for you, but we do have a bunch of slides on these topics. There is a current bill pending that pertains to a lot of the issues we're going to talk about in a minute, changes or proposes to change some of the items that pertain to these structural integrity reserve studies, milestone inspection reports. My suggestion, if you want to know what's going on right now, Jeff Rembaum, my partner, and I did a webinar with Castle Group on January 17th of this year, which is available on our website. Go to kbrlegal.com under the resources tab. That's going to tell you what's going on currently in the legislature and what's being considered that isn't law yet. Our goal today is to go through what the law actually says as of now. But I do want to point out one big change that was made or one change that's proposed that would be huge for condos and co-ops in Florida, and that is that the proposed bill directly authorizes a special assessment to fund loans or lines of credit that are intended for repairs, maintenance, or replacement that's required pursuant to a structural integrity reserve study, a milestone inspection report, or another local inspection requirement, or to fund unanticipated repairs that's approved by the board without a member vote. So that's a lot of words. Here's what it boils down to. Before, we'll get into what is required of condos and co-ops in Florida that wasn't until 2 years ago. What it really comes down to is huge new assessment amounts that the association is obligated to fund and to store for purposes of dealing with assets of the association. When these amounts increased, the association didn't necessarily have a mechanism to pay those assessments, pay those charges for the work that you're finding that needs to be performed within the community to protect the structure of your buildings and your infrastructure. Now, the bill would basically allow the association to say, we don't have the authority to levy a special assessment, but we need this money. We can't get a loan because we can't pay the loan without a special assessment because we can't increase our assessments by hundreds of thousands of dollars without going over that 115% rule. Now, it doesn't include reserves, but this is the argument I'm hearing, is that the 115% rule somehow pertains to this issue. Okay, if you've got something in your covenants, there's already something in the statutes, make sure that you understand if this goes through, the association is going to have a mechanism to fund its required repairs, maintenance, and replacement of important components of the community. So I'm really hoping that one thing goes through. The only other one that I think is a great idea this year is the education component. But again, check out our Castle webinar. I think Jeff Rembaum was the one that went through this particular issue, and it is very important. So moving on, what's a milestone inspection? So this has been redefined. And just to be clear, the items that are in red in the slides that you're going to see are all changes that have been made. So a milestone inspection is essentially a study that is performed by a professional, which is now going to be either a licensed architect or engineer or someone operating under them, a team operating under a licensed architect or engineer. That's one of the changes made this year. And the purpose of that inspection is to basically identify issues that could impact the life safety of the building, meaning if there is a structural defect that is visible, that phase one inspection, and there are two potential phases that we'll get into in a minute, but that first phase, that visual inspection, hopefully will show that there's a problem here. So that's the purpose of this milestone inspection, is literally just someone that should know what the heck they're doing comes out and looks at the property. And if they don't see anything that's immediately wrong, you don't have to do anything and go forward with phase two. That's really what we're talking about. It's determining the general structural condition of the building. Now, just so you understand, the purpose of this is not to determine whether this building meets existing fire safety code requirements or building code requirements. So just understand, all they're doing is looking at it and saying, is this safe? Is there a problem that I can see? Who does it? I talked earlier about last year. It was, well, 2022. It was that an architect or an engineer was required to be the one that actually performs this milestone inspection. Okay, that visual inspection. Now, again, we've added a team that is working under the direction of one of those two individuals. So it just opened it up to other people to actually perform this work. Part of the reason for that is because attorneys like the ones in our firm, I think there were 6 or 7 of us, who were arguing, well, listen, that's great. We understand you want us to make sure after the Surfside building collapse that everything is safe in these condominium buildings and these co-op buildings. Certainly an important concept. But if you're going to say that everyone needs to do all of these studies by the end of 2024, think about how many condos and co-ops exist in Florida that are 3 stories or higher, which we'll get into later. Think about how many of those exist and how many architects and engineers are licensed to actually do business in the state of Florida. There's certainly not enough labor to meet the need to actually allow people to comply that want to comply. Within, at the time, it was like a year and a half. And also, realistically speaking, most condos and co-ops are not doing it immediately. They're trying to book something in June or July of 2024 so that it's hopefully done by the end of the year. So this, again, just opened it up to more people that are able to do these milestone inspections and tell you whether there's something obvious, visually obvious in your building that's unsafe that needs to be repaired. The term substantial structural deterioration, which is what these individuals are now looking for as part of your milestone inspection, is also defined to mean substantial structural distress or weakness that negatively affects a building's general structural condition and integrity. Meaning, is it truly a problem or is it just something that doesn't look right? Now we are saying this is most likely a true problem. This only applies, keep in mind, if you're in a smaller building, it might not apply. You might not need to do all of this. That doesn't mean it's a bad idea to have these visual inspections and potentially destructive testing performed anyway to make sure that you're reserving properly and that your building is safe. But the purpose of this legislation is allegedly to protect larger, taller buildings where, if you're on floor 1, you might be able to run out the door and be safe. If you're on floor 20, you might not have time to grab the elevator while the building collapses. So I hate to be fatalistic, but that is the viewpoint of many of the legislators that are creating this legislation. So if your building is not 3 stories or more in height, it is not subject to milestone inspection reporting. It may still be subject to local inspection requirements, but it's not going to be this specific statutory requirement. Similarly, if you are in a commercial or any other type of condo or co-op other than a residential community, you don't have to comply with this. Again, still not a bad idea, but it's not required. Residential mixed use and condominium hotels are another thing that is not obligated to do any of this, except to the extent that that community, that condominium association, is part of a residential condo, meaning that there are members that actually reside there, and that it is a portion of the building that that condo is obligated to maintain. So if let's say you're in a hotel condo, the hotel condo owner, not the condo owner, but the hotel owner, is obligated to maintain the windows. Those are not going to be part of this type of study because they're not something that the association, the residential condominium association, is obligated to maintain. So just understand, pure commercial buildings are completely excluded from this. Commercial portions of buildings that are not governed by the condominium structure in a residential condominium are also excluded from this reporting and this inspection requirement. When is this required to happen? So if you are subject to this, then you need to have this milestone inspection, at least this first phase, done by December 31st of the year in which the building reaches 30 years of age, based on the date of the certificate of occupancy, and every 10 years thereafter. So these are the milestones. It's the first 30 years and every milestone of 10 years thereafter. Now, if that 30-year date happened before July 1st, 2022, you have until the end of this year to perform that milestone inspection. If it's after July 1st, 2022, but before the end of this year, the initial inspection needs to be performed by the end of next year. So what we're saying is, listen, it's 30 years in general, then every 10 years thereafter. But if you've got a building that's already past 30 years, you got to get this done. Now, the good news, another thing that was added this year, if the milestone inspection is completed within the last 5 years and meets the requirements under the statute for what a milestone inspection needs to include, needs to evaluate, needs to incorporate, that inspection can be used and you don't have to get another one except for within that 10-year period. So if you've already had, let's say you're in Broward or Miami-Dade counties and you have a specific 40, 30-year certification requirement, you had that done 3 years ago, you might be able to use that. You might want to go back to the individual or the entity that performed that inspection and check with them as to whether or not their opinion, which you might want to get a formal opinion from counsel as well, but check with them as to whether they think that this inspection report meets the requirements for the milestone inspection. If so, you might be able to avoid the need to have yet another inspection within those 5 years. And that was a logical change that a lot of attorneys, including several from our firm, were asking for, because if this was all already done a year ago, why do I have to have it done again just because the legislature decided that I need to do it? When you don't have a certificate of occupancy, because keep in mind that these 30-year dates that I just mentioned are based on when the certificate of occupancy was issued. If you got a 60-year-old building, it's entirely feasible that you can't find that certificate of occupancy date. If that's not available, the building the building certificate of occupancy is considered to be the date that there's any evidence whatsoever in the records of the local building officials. That's usually going to be the county or the city, that someone was occupying a portion of the building. So can't find the CO, basically you go by literally any document that indicates when someone occupied one of the units within the building. Now, another change that was made, it used to be before this past year that there was a 25-year requirement instead of 30 if you were within a specific location within 3 miles of the coastline. That came out this year, so there's no 25-year versus 30-year. It's just a flat 30 years across the state. However, the local enforcement agency, again, your county, your city building department, or whoever is enforcing these requirements, can still say that a milestone inspection needs to be performed sooner based on their determination that you are close to the coastline. And frankly, from my perspective, it makes sense to make a building that is adjacent or very near to salt water do it before a building that's not adjacent to salt water, because what we're talking about is what is the deterioration factor that salt water causes. I can almost guarantee that unless you are redoing all of your sealant, all of your paint, and everything else that's associated with that potential breakdown due to salt water every couple of years, your building's going to be in much worse condition overall than one that's located in central Florida, nowhere near the coast. So again, it's the local enforcement agency can basically tell you, even though the statute doesn't say that you got to do this sooner, that the local enforcement agency can say you have to do it by the time you reach 25 years or later. And then it's 10 years after the date of that inspection that you would need to do the next milestone inspection. Now, again, we've identified that there are problems trying to get the labor to actually perform these inspections. So there is a provision that was added, and actually more revised than added, that if you've entered into a contract with an architect or an engineer to perform the work, the local enforcement agency may, note this isn't must, may, meaning they have the ability, but they don't have to grant an extension of the time. Let's say you were required to do this by December 31st of 2024 under the timelines that I provided earlier as your initial milestone inspection. The local enforcement agency, the city or county, can say, well, we understand that you've got a contract that says that the work's going to be done in March of 2025. We'll allow that, but they don't have to do it. And frankly, they don't even have the authority to do it unless you've got the contract and you show why the association wasn't able to get someone in sooner and comply with their obligated timelines. So just understand, this is not like well, we'll ask for an extension and it'll be granted like in a courtroom sometimes. This is more of hey, you got to get your ducks in a row. You got to do what you're required to do. And if you're still not able to get into compliance, then the local enforcement agency might be okay with an extension. Now, I haven't heard of any local enforcement agency outright rejecting all of these proposals. I anticipate that if you're trying to do what you're supposed to do, they might work with you, but there's no guarantee. So just do what you're supposed to do when you're supposed to do it. If you start trying now, I can almost promise you'll find someone that's able to do that milestone inspection. And we do have several vendors that we work with on a fairly regular basis that can do that. You'll find someone that's willing and able to do it, that is competent in this area of work before that deadline expires. Moving forward, if your report was prepared before July 1st, 2022, The local enforcement agency may adopt an inspection report. Again, this kind of goes back as part but separate to what we discussed earlier about the reports that are already in existence before the statute went into effect. If the inspection was completed, the association still needs to comply with the unit owner notice requirements. Now, there's a proposal right now that would be within 45 days after receiving the report, the association needs to mail a copy or send a copy to every member of the community or notify them that a copy is available upon request. This is something that frankly makes sense. You would want people to know about the condition of the building because as much as you may not want them to know if there's a problem and you just want to take care of it, they need to understand why their assessments are inevitably going up. So providing this is not a bad thing. Even if there is a problem that's identified, again, you're going to tell them, hey, we've got this problem, we're taking care of it, but that taking care of it portion is also why your assessments are increasing this year. In addition to, obviously, the additional insurance costs, the mandatory reserves that you weren't supposed to keep before or required to keep before, et cetera. If the inspection report that you've already got is accepted by that local enforcement agency, the deadline for the building's 10-year milestone inspection is based on the date of that previously accepted inspection. So again, just like I mentioned earlier, we're going to the date of that original inspection that was within the last 5 years. And we're going 10 years from that date, not from today's date or the date that the local enforcement agency accepted that inspection report. Okay, moving forward. And yes, I fully expect that there's going to be 100 questions about this stuff. That's why Jeff mentioned earlier that we will open the Q&A a little later, but we're on slide 15 of 89 right now, so we're not quite there yet. But we are about a quarter of the way there, so congratulations. Mixed use and condo hotels. So the milestone inspection report is done by the Residential Condo Association and any owner of any portion of the building that is not subject to the condo or co-op. So that milestone inspection does not necessarily get done if it is not part of the condo, not part of the co-op, because it's not the co-op or condo's responsibility to maintain it. Any owner of the building that isn't part of that is responsible for ensuring compliance with the requirements of the milestone inspection reports. The condo association or co-op is responsible for all the costs associated with the milestone inspection that pertain to the portions of the building for which that association is responsible. So what this is saying is essentially you're responsible for having the inspection done on the portions of the building that you have to maintain, and you as an association pay that cost, not the hotel owner, not the mixed use owner, not the commercial owner. And I don't think we've mentioned this, but keep in mind, this is based on each building being 3 stories or higher. So if you've got 20 buildings and only 2 of them are more than 3 stories, you don't need to get them on the, you don't need to get this done on the 18 buildings that aren't. Moving back, governmental notice and association obligations for phase 1. If the local enforcement agency decides that a milestone inspection is required and hasn't been done, they do need to provide written notice of that requirement. That notice goes to the association, and any owner of a portion of the building that isn't subject to that form of ownership by certified mail return receipt requested. So you should be getting this done anyway, but the local enforcement agency is generally going to be the one that sends you a notice saying, hey, you have to get this done within a certain amount of time. That amount of time is within 180 days. So they can't require you to get it done in essentially less than 6 months, because let's be realistic, as of right now, that might not even be feasible, even if you go out today and hire a contractor to go out and take a look at your building. The association does need to notify the members of this milestone inspection requirement, not the general requirement, but the requirement that's set forth by the local enforcement agency. So don't think that you need to send a letter to all of your members that says, hey, this statute changed, we need to do a milestone inspection. This is only if you get a notice from a local enforcement agency that you give 14 days after receipt of the written notice from the local enforcement agency. And then you also need to evaluate, determine, and provide the date that the milestone inspection needs to be done within that notice. Phase one is literally a visual examination of the habitable and non-habitable areas of the building. So again, just understand this is purely visual. This is not destructive testing. This isn't even pulling things off with my hand. It's walking around and looking and saying, okay, well, that looks fine. Up, I see a crack in the stucco there. That might be an indicator of some kind of problem that goes a little deeper. We need to delve into that. If there are no signs of, and again, we talked about the definition of substantial structural deterioration. If it's just a line on a building that's, someone put a marker on the paint, that's not something that's going to be problematic. It's not going to require a phase two inspection. Okay, but phase one, again, is determining whether there are signs visually of substantial structural deterioration to any building components that the association is obligated to maintain. Now, how are you going to determine excuse me, let me take a sip of water. All right, how are we going to determine who's obligated to maintain those components? Look at the declaration. Done. That's easy. Now, that might require the involvement of your counsel, but it is something that can be done to determine who's responsible for what. Now, that gets a little bit more tricky when, again, we're talking about the multi-use condo, the hotel condo, the commercial/residential condo situation, but it is something that your attorney should generally be able to determine if you need the attorney's involvement. Moving on to phase two, this is where this must be performed if there was structural deterioration identified during phase one. Okay, phase two might involve destructive or non-destructive testing. The inspector is going to get to make that determination. It can be as extensive or limited as necessary to actually assess what the damage is and what it's going to take to repair that perceived damage, that structural problem, and recommend a program. Now, this program is basically step by step. What do you need to do to make this building safe and remove this structural problem, this substantial structural deterioration? If phase two is required, then within 180 days, again, about 6 months after submitting the phase one inspection report, the architect or engineer needs to submit the phase two progress report, meaning where are we at within this phase two? Have we done the destructive testing? Have we given a report for the destructive testing and what is needed? What is this program to rehab the building actually look like? Wherever the inspector is at in that process, that's what goes into this report that goes to the local enforcement agency with a timeline for completing the rest of that phase two inspection. Now, that completion of the phase two inspection doesn't need to include all of the curative actions that the association needs to take. All it really includes is here's what's wrong. Okay, so don't think that it's going to be a plan that goes 2 years out. It's here's what we have done, here's what we still need to do in order to have the inspection and reporting completed before the work even starts. After the milestone inspection is completed, whether that's phase one or phase one and two, the architect or engineer submits a sealed copy of the inspection report with a summary of the material findings and recommendations to the association and to any other owner of the portion of the building that's not subject to condo or co-op ownership. The reason that these other people get this notice is because the components of the association might impact the components of the rest of the building. That could be, again, we're talking about what is safe and what is not from the perspective of the structure of this building. So if the structure of the association is only a portion of the structure of the building, we want to make sure that everyone that's involved here knows what's going on. And again, within 45 days after receiving the inspection report, the association sends a copy of the summary, not the whole report, but the summary to each owner, regardless of what's in there, and basically says, hey, here's what's going on. Now, most likely, once you get that report, you're also going to have a plan of how to fix everything. So some communities will actually send this report out in conjunction with a notice of, let's say, a board meeting where you're deciding whether to perform work on the community that's been recommended by the inspector, the architect, the engineer, the team, etc. That notice can go out as one mailing. The association must also post a copy of the inspector prepared summary in a conspicuous place on the property so that everyone has a better chance of actually seeing it versus those individuals who choose not to collect their mail for 3 months or live outside the country and never bothered to provide you a mailing address. I know that never happens in Central Florida or Miami. The association must publish the full report and inspector prepared summary on the association's website if you need to have a website. Now, right now, we're at 150 units for the requirement to have a website for condos. Just understand there is a proposal out there right now that would require it for any condo with 25 units or more. Basically, most of the condos, to my knowledge, in all of Florida. So just be prepared if you don't already have a website. If you have a management firm, work with them on getting that accomplished. If you don't have one, there are plenty of vendors out there that frankly specialize in creating association websites. So I would suggest that you get your ducks in a row, get that moving so that, again, you're not behind the ball when inevitably you might be required to have that website. And frankly, it just makes it easier when you can direct people to that website instead of saying, come on in, take a look at all of our records. Local government enforcement or repairs, the Board of County Commissioners or municipal governing body, again, we're talking city or county, may adopt an ordinance, which is just basically a local law requiring that the association and any other owner subject to the milestone inspection reporting requirements begin the repairs within no later than 365 days after receiving the report. Meaning the local enforcement agency can tell you, great, you know there's a problem now, get to work. If the owner of the building doesn't submit proof, then the local government must review and determine if the building is unsafe for human occupancy. So that's one more reason to get moving on your work and submit these reports, because otherwise they're going to come in and decide whether to shut down your building altogether and kick everyone out and condemn it temporarily until the repairs are done. And I promise you, you do not want to deal with the screaming owners who are telling you that they want you to reimburse them, even though you have no obligation to do so, for their hotel stay for the time that it took to get this done, even though they're not actually living in the unit. Moving on. By the end of this year, the Florida Building Commission needs to adopt rules establishing building safety program, which basically implements all of these milestone inspections, the testing protocols, etc. This is not something that you guys need to worry about, but just be aware there's another set of rules and regulations coming down the pike at some point before the end of the year. Or my guess is that the Florida Building Commission hasn't done this in time. The legislature will just kick the can down the road to December 31st, 2025. So moving on to structural integrity reserve studies. This is a very similar concept. Again, we're talking structural reserves that are mandatory for your association. So the exemption, if your assets life, and let's talk about what a reserve is before I get into this. A reserve is literally dollars that you're putting aside because you know that an asset of the association, whether it's a roof, windows, your roads, something of that nature, is going to fail at some point down the road, and you're going to have to repair or replace it. But this isn't something that you do once a year. It's not ongoing maintenance. It's, well, every 10, 15 years, we have to replace this asset, or we have to do, 15 grand worth of repairs to this asset. That's what you're putting money aside for. So what the law added 2 years ago, the legislature said, yes, we've got 4 or 5 components already that you need to save money for in order to have the funds to do those repairs immediately when they're needed, so that you're not stuck with leaks in your roof almost permanently or a special assessment for hundreds of thousands of dollars that your members didn't expect to have to pay. You're saving that money over time during the estimated useful life of that particular asset. So what this is saying in this slide is, if that estimated useful life is more than 25 years, or you can't decide what that useful life is, because frankly, it might last forever. Let's say you've got a 40-year roof, okay? There's no reason that you have to put money away for the next 40 years. It makes no sense for you to have that money just kind of sitting there and waiting to be used 39 years from now after this year. So the legislature, wisely, in my opinion, says that if you can't determine what the useful life is, you don't have to reserve for this. You can, but it's not mandatory. If that useful life is believed to be 25 years or greater than 25 years, I mean, not 25, but more than 25, you also don't need to put that money away until it's less than 25 years out. So for that 40-year roof that we put on this year, we've got another 15 years that we don't have to levy an assessment or add to our assessment and reserve funds to repair or replace that roof. But the association must reserve the amount of deferred maintenance expense, if any, which is recommended by the Structural Integrity Reserve Study for those items. So when you have this study done, and it's again going to be done by an architect, engineer, or team that is working under their direction, and you get the reserve study telling you you need to save X amount for the roof and it'll probably fail within 15 years. You do need to follow that. But if it says, well, it's expected to fail in 26 years, there's no need to reserve for it. You guys, as an association, can rely on that statement of the architect or engineer. You can adjust replacement reserve assessments annually to take into account inflation, meaning, let's say they're doing the work now to do the structural integrity reserve study. You've got it done. It says that you need to save X dollars, but you know that due to inflation every year, rising costs in materials, rising costs in labor, that this project is actually going to cost the association 3 to 5% more as of every year. Well, you don't want to have the amount that was in that study by the end of year 15. You want to have the amount that was in that study plus an estimated amount that this is going to go up. So that estimate, if you choose not to have another reserve study between now and year 15, that estimate is going to be whatever the amount of inflation is. And that's going to be determined by some kind of official inflation determination. So it's not going to be just, well, it's 2% for inflation. It's going to be, well, this index says that inflation was X in 2024. So our budget for 2025 accounts for that percentage of increase when it comes to all of these reserve assets. What this says is that's allowed rather than just reserving the wrong amount for that 15-year period. Exemptions to the requirements we already talked about, so we can move through this. In a budget adopted by an association that must maintain or obtain a structural integrity reserve study, those reserves must be maintained for the items that are listed in subsection 718.112 sub 2G. We just call these little g items because let's see if this pops up. There it is, little g. So that's what we're talking about here. The association must reserve for those items if the CEUs says that you must. So CEUs is Structural Integrity Reserve Study. I'll probably save 5 minutes by referring to it that way from now on. So a residential condominium has to have a CEUs completed at least every 10 years after the condominium's creation for each building that's 3 stories or higher in height, determined by the Florida Building Code. Okay, now these components, which I won't read out to you, you can read it from the slide. And we will provide copies of this slide that are going to be available once you complete your survey later today. But, excuse me, this catch-all in subsection H here is the one that I really want you to focus on. Any item that has a deferred maintenance expense or replacement cost of over $10,000 and is going to negatively affect the items listed above, as determined by the visual inspection portion of the CEUs. Meaning if there's a structural or a component of your association that would cost more than $10,000 to replace or maintain in any given time that impacts your roof and all of these other things, you also need to reserve mandatorily for that item. Now, again, this is going to go into the report that the investigator is going to provide you at the end of this CEUs process. So it's not that the association needs to make this determination. Matter of fact, you shouldn't be making this determination unless you are an engineer or architect that has been hired for this purpose. And we won't get into conflicts of interest. We have a separate class on that. The CEUs, the difference between 2023 and 2022, which is this is version 2.0, version 3.0 is what's being proposed now. The terms floor and foundation were removed from what you need to actually say. They're potentially part of the structure, but frankly, if you're removing the floor or foundation from your building, that's called a tear down. I don't know how you can replace the foundation of a 5-story building without basically tearing down that building. I'm not an engineer. I haven't been involved, I guess, in enough construction issues to have that answer, but I haven't seen it done. So the argument was, listen, it's completely illogical to say we got to protect for problems with the foundation. You still need to fix problems with the foundation, but it's not something you're going to reserve for, because frankly, you might end up with a termination of your condominium if you have to tear down the building and rebuild. Moving on, the CEUs must identify each item being visually inspected, meaning here's what we actually looked at. It needs to state the estimated remaining useful life and provide a reserve funding schedule with recommended annual amounts. In other words, this is a visual inspection that is basically saying, hey, here's how long I expect this component to last. Here's what you need to have when we're expecting it to fail. Have at it. Now, once the association receives that report, that assessment is going to probably increase because you probably haven't been reserving for all of these new mandatory items. So a lot of communities are somewhat intentionally deferring this for as long as possible. I'm not suggesting that you shouldn't do that, but what I am saying is, again, remember that it's up to the local inspection agency to say whether you get that extension or you're in violation of this requirement. And another one of the bills that is currently pending would make it a breach of fiduciary duty, meaning you can be sued individually if the association doesn't get this done in time or doesn't get it done at all. So just understand, you're protecting yourself as a director and an officer by making sure this gets done in a timely manner pursuant to statute. The requirement to have this CEUs performed in the first place does not apply to certain types of buildings. Again, this isn't every condo or co-op in Florida. It doesn't apply to buildings less than 3 stories in height, doesn't apply to single family, 2-family, or 3-family dwellings with 3 or fewer habitable stories above ground, doesn't apply to any portion of a component of a building that hasn't been submitted to the condominium or cooperative form of ownership, and it doesn't apply to any portion of the building that's maintained by someone other than the association. And yet again, it does not apply at all in a commercial condominium. So this is residential. We talked about who can perform this. The deadline for the CEUs as compared to the deadline for the MIR. We talk about MERS and CEUs, which is not my line, but I think it's hilarious, so I use it anyway. Associations that existed, meaning your declaration was recorded on or before July 1st, 2022, that are unit owner controlled, meaning the developer is not still in control, must have this done by December 31st, 2024 for each building that is operated by the condo that's 3 stories or higher in height. If you're required to have a milestone inspection before December 31st, 2026, based on those requirements that we talked about earlier, meaning that that date is 30 years from your certificate of occupancy, you can complete the structural integrity reserve study simultaneously with the milestone inspection report, but you can't have it done after December 31st, 2026. Now, when we say in no event, we mean there's no extension of that deadline available. So if that's something you want to do, which frankly might save you significant time and money when you're getting one person to do all of this inspection and reporting, that's certainly something that might be in the best interest of the association. Just make sure that if you're going to defer these 2 reports, defer these 2 inspections, that you're doing it in a way that isn't going to get your community in trouble and frankly get you personally in trouble as a director. You can adjust again for inflation when you're changing your mandatory reserve amounts. So every year you just adjust for that inflation to try and make sure that you are actually reserving enough money to address when that component fails. Waiving and reducing reserves has also changed. The members of a unit owner controlled association can determine by majority vote of the total voting interests to provide no reserves or less reserves than required by statute. However, for these little g reserves that we referred to, the mandatory ones, if your budget's adopted on or after December 31st, 2024, so by the end of this year, instead of January 1st, 2025 or later, then the members of a unit owner controlled association that needs to get a CEUs done cannot provide no reserves, cannot provide less reserves than required based on the inspection that's been performed. Okay, you would need a new CERS that says you have repaired these problems and no longer need to reserve these amounts until X date. If an alternative funding method has been approved by the division, that may be an option, but there's no 100% clear definition. Let's get into what an alternative funding method is. It's basically a method approved by the division for funding capital expenditures and deferred maintenance obligations for a multi-condo operating at least 25 condos, which may reasonably be expected to fully satisfy the reserve funding obligations by allocating funds in the operating budget. What this means is for multi-condos, you might be able to avoid the reserve reduction or elimination restrictions that I talked about in the last slide. But again, this is only in larger condos that have 25, not buildings, but 25 condominiums. Okay, so we're talking about a large master association that governs multiple condominiums. Same thing with using reserves for a different purpose. That can be done for now by member vote of a majority of the members, but for a budget adopted on or after December 31st, 2024, cannot be done at all. So you can only use those funds for the purposes for which they are being reserved and for which they are intended after December 30, in a budget that's adopted after December 31st, 2024. Now, there are two different methods of calculating your reserves and maintaining your reserves. One is the straight line method. That means I have a roof that's going to cost $100,000 to replace. Cheap roof, congratulations for a large building. That's only going to last another 10 years. That means I save $10,000 per year during that 10 years. Pooling means you have 20 different components that you shove into a pool and you put money aside so that as each component is expected to fail, you have the amount that you think you'll need to fund that repair, that replacement. Okay. It's really an accounting function that you'll want to check with both your accountant and your association counsel. But the bottom line is the Florida statutes regarding these sub little g items don't actually clearly provide for pooling. Now, DBPR has expressed that they think it's probably okay, but they have vacillated a little bit on even that issue. And you never know when a new Q&A is going to be put out by them that suddenly says, no, you can't pull your reserves. And the question then becomes whether you can pull out the funds that you have when they do say you can't pull your reserves anymore, because you're no longer allowed to move those funds anywhere other than where they're located. So my concern is by pooling and relying on something other than the Florida statute or the actual Florida administrative code and saying, yeah, we can pool this, you might be putting your reserves at risk. And frankly, you might risk having to put aside significantly more than you thought once all of this changes if you want to switch over to a straight line method, which tends to result in more reserves than the pooling method anyway. But if you have it in a pool and all of a sudden you are told you're not allowed to have it in a pool, it becomes extremely difficult to try and pull those particular funds out. So just be careful, get advice of counsel and your accountant before you decide to pool these mandatory reserves. Maintenance of common areas. After turnover of control of the association to unit owners, the association must perform maintenance identified by the developer until the association obtains new maintenance protocols from a licensed professional engineer or architect or someone certified as a reserve specialist. What this means is if it was being maintained either poorly or improperly or even properly, the association still needs to perform the maintenance that hasn't been done and is identified in the turnover report and the engineering study. What I would suggest is even after turnover, get your own engineering report. The reason for this is that I don't anticipate that the person that does the developer's report is going to be biased in any way, but having selected your own engineer, you know exactly what their credentials are, and you know that there's someone that you would want to be performing this type of work to tell you what's wrong with your community so that the developer might be obligated to fix it. We'll get into the timeline to make that demand a little later. If there's a dispute effective July 1st, 2027, if there's a dispute regarding the milestone inspection and CEUs or CEUs, the term dispute in 718.1255, which basically goes to mandatory non-binding arbitration or mediation before you can file your lawsuit to address those types of issues. This is going to be added. Any dispute regarding the MERS and the CERS is going to be added as something where you don't just go file your lawsuit. You have to either file for pre-suit arbitration or pre-suit mediation. My recommendation is pretty much always go to mediation and let a judge decide instead of an arbitrator, but that's something that you can discuss with your counsel if it gets to that point. Owner disclosure requirements, frankly, I think we can skip through. They're in your materials, but that's owners who are selling their units need to make certain disclosures. And again, the developer requirement to provide the CERS as part of the turnover exists. Make sure that you get it as part of that turnover process. They should have already done it. Again, the developer turnover report should include all of the components that are listed here that should be in your CERS. In addition, regardless of when the CO was issued, the turnover inspection report included in the official records should include all of these additional items so that you know what the condition allegedly was as of the date of the inspection. So HOA folks, congratulations for making it through the first almost hour of the presentation. We can now move on, fortunately, to all the other stuff, and much of this will impact HOAs, but unfortunately, this first one won't. The official records of the association have always been open to inspection by the members. Now, the statute up until July 1st of 2023 said that a member or their authorized representative could perform the inspection upon request. In condos only, this was changed in 2023 so that the owner, the member, and their representative is now authorized to perform the inspection, meaning that owner can now sit with their buddy, with their attorney, whoever's been designated as an authorized representative for purposes of the inspection, and actually go through the records with them. So it's no longer one or the other. Now it's you can do both, or let me be clearer, the member can require the association to allow both of those individuals to be there for the inspection of the official records of the association. So again, this is condo specific. I don't think that the change was made for co-ops, and it definitely wasn't made in 2023 for HOAs. Another condo Patriot Day was added. That's September 11th to the list of days when a condo unit owner can display armed forces flags. I'm on board with that one. HOAs, congratulations. You've got flags. This is the first HOA one of the day, and we'll be vacillating between condo and HOA going forward. But this basically is a restriction or a rule that went into place under Florida law. The association in an HOA no longer has the ability to restrict certain flags being flown. So in an HOA, an owner can now display up to 2 of the following flags in a respectful manner. This is the U.S. flag, the state flag of Florida, the military flags, including the Space Force, a POW MIA flag, and a first responder flag. And in addition to that, just understand this is in addition, a homeowner can fly 1 U.S. flag and 1 flag from the list above from a freestanding flagpole. Now, you do have the ability to restrict certain locations for that flagpole, but just understand if you're in an HOA and an owner has a flagpole that's been allowed under the statute and by the association, then they will have the ability to fly 2 of these flags, or the U.S. flag and 1 of these flags from that flagpole, in addition to what they're allowed to have on the residence itself. This one makes me want to kick or punch something very hard. This is one of the worst laws that's come out since I became an attorney and started practicing in this area of law in 2010. It essentially says that regardless of your covenants that have been in place since the 1970s, potentially, and regardless of the Florida Constitution and the U.S. Constitution that allows for contracts to remain the way that they are and be enforceable without interference by the state, now you've got interference by the state. So if a covenant restriction or other requirement of an association exists, it is unenforceable if there is a restriction that says something cannot be installed, displayed, or stored on a parcel that isn't visible from the parcel's frontage, meaning from the street in front of the front door up to the boundary lines on the sides, or from an adjacent lot. Now, what is an adjacent lot? It doesn't include the lot across the lake because the lake is adjacent to the lot. So I have to look at my neighbor's boat across the lake, and I'm not saying me, I don't live on a lake, and my neighbor certainly doesn't have a boat on the property, but I have now the obligation to ignore the existence of this boat unless it can be viewed from the front of the lot or from the sides or from behind, over a fence or around a fence. Understand there are some limitations to this law. It's just installation, storage, and display. So that means that if it's a condition, if it's someone screaming but isn't visible and you can hear it, or if it's a smell emanating from the lot, or for example, one of the things that I've already started to see since this law went into place, and someone paves their entire backyard, but now there's zero drainage whatsoever in the backyard, so rainwater starts to flow over into common areas, those violations are separate and still enforceable. So just understand, and there is another bill that's pending regarding HOAs and enforcement via fines and ARB approvals. I'm not going to go into it. Check out our Castle webinar that I mentioned earlier that I'm sure Jeff will share the link for at some point throughout the presentation today. But the bottom line is there are significant limitations to this law. I won't go through them in detail because frankly, I want our clients to benefit from our creativity and not give away our tricks and secrets to the other side of these types of disputes. But just understand there are limitations to this law. It's a terrible law in my opinion, but it does apply in Florida until someone challenges it successfully and the Florida Legislature, or I'm sorry, a Florida Supreme Court says that this law is unconstitutional as applied to pre-existing restrictions that exist in a contract between the members and the association, which is your declaration of covenants. Moving forward, HOA Bill of Rights, another fun one. I think this makes sense. All board meeting notices must fully identify all agenda items for the meeting except emergencies in an HOA. Now, that's always been the case that you should, in my opinion, provide all of those agenda items, but now it's mandatory. So just understand when you have new business, old business on the agenda, you got to be a little bit more specific than that, in my personal legal opinion, because you need to now specifically identify them, not just have a bunch of stuff that's on there and then deal with whatever comes up. If you know what's going on 2 days in advance of that meeting and you've got 48 hours to post or share that notice, you've got 48 hours to know exactly what you're going to discuss during that meeting. And if it's not on the agenda, you can still deal with it after the fact, but you may need to have that decision of the board ratified at the next board meeting or potentially via a written agreement of the directors, basically a written resolution that all of the directors unanimously sign unless your bylaws or articles of incorporation say you can't do that. Moving on, official records, you do need the current roster of members. You also need now to maintain the designated mailing addresses, which is considered the property address within the association, unless the member has sent written notice to the association saying they have a different mailing address. So before it was just, well, the property address is the property address. If you have no mailing address, your roster should generally include now a specific reference to the property address. Same thing with email addresses and fax numbers that are provided for purposes of the association providing notices to these members. Now they can request that this information be removed under 720, which is the HOA chapter of the Florida statutes, but they need to actively request that the association remove a specific email address or mailing address from the association records. And generally they are doing that in conjunction with revoking the ability of the association to send notices there when they're providing a new address. Moving forward, and by the way, sending notices via email is not always going to be something that's acceptable. It's acceptable if the individual member has consented to being provided notices in that manner. If that member hasn't agreed to accept notices, you still got to mail or hand deliver. Deposits, if you're getting a deposit for any reason, usually this is going to be someone's got work going on their lot, or you've got a tenant that is moving in and out and might damage common areas of your HOA. Those funds that you're getting, that deposit, may not be commingled with any other association funds, meaning they get maintained in a completely separate account. You can't shove everything together and just put that in your operating account. Once the project's done, the deposit does need to be returned, and this says to the member. That makes it a lot easier, because before there was a question as to who gets that money back. The member gets that money back within 30 days after receiving notice that the construction project, or whatever the reason for that deposit was made, is now complete, meaning that deposit is no longer something that's required under your governing documents. If the owner who paid that money requests an accounting from the association only has 7 days, calendar days, after receiving that request to provide that accounting. This is part of why it is so important now to not commingle those funds and just shove them in operating so that you can't track them anymore. Moving forward to kickbacks, they were, well, not always, for the last, I think since 2017 or 18, they've been actually considered a crime, a misdemeanor in a condo, meaning kickbacks are generally going to be when you are getting something of value in exchange for working with a vendor or something of that nature. Those kickbacks have always been wrong ethically, but now they are clearly prohibited under the Florida statutes. If you knowingly, and this is an officer, director, or manager, knowingly solicit, offer to accept, or accept, meaning you don't even need to ask for it. If it's offered and you say, yeah, that's okay, I'll take that money, or I'll take that thing or that service, anything of value that you haven't paid for that benefits you or your immediate family, that from someone that proposes to provide goods or services to the association, there are automatic monetary damages that apply to that individual. In other words, the association is owed that money under Chapter 617 of the Florida statutes, which is the not-for-profit corporation statute. If the board finds that the officer actually violated this, the board immediately removes that individual. So it's not a, well, you know, we're going to suspend you. Nope, you're off the board and your spot is filled, either according to law, which generally is going to be that the association board can either appoint or have an election to get a new director in that spot for the remainder of that director or officer's term of office. You can, by the way, accept food to be consumed at a business meeting with a value of less than $25 per person, or a service or good received in connection with trade fairs or education programs. This was already in the statute. What this means for practical purposes is, if you accept something that isn't one of these two things in the last slide, and it has value and you didn't pay for it, and it has anything to do with association business, you're probably off the board and you might be subject to civil penalties. Long story short, you're in trouble and you might end up owing the association a bunch of money. Don't do it. That's the bottom line. If someone offers you something, you pay for it. Now, if it's, you know, we'll take you to lunch during an educational program, fine. But just be careful about what you're accepting. Frankly, if someone makes that offer, I'd run it by your attorney before you say, yes, please. Or even say, okay. Enough other grounds for immediate removal of a director or officer from office that are new this year. If there is a forgery of a ballot envelope, in other words, voter fraud by that director or officer, theft or embezzlement of association funds or property, destruction of records or refusing to allow inspection or copying of association records with the intent to basically hide a crime. And when it says in furtherance, that's really what we're talking about. Obstruction of justice is the other one. So, just understand that if the officers or directors do any of these things and get caught, which they will, they are not allowed to be on the board anymore. They're off. And you fill that spot either by appointment by the rest of the directors, which is just a majority vote of a quorum, or you have another election, which frankly is a lot of headache and probably not worth it and not necessary under Florida law. So my suggestion, make the appointment. Conflict of interest disclosures for developer appointed board members and officers. Literally all this is once a year, if you were appointed by the developer as a director or officer, you need to disclose your position and relationship to the developer, to the membership. That's it. Moving forward, if we can. Okay. So this is disclosures of conflicts of interest for a member elected board member or officer. So this is a standard conflict. Bottom line, you need to give 14 days notice of the conflict before the board meeting at which that contract, that service is going to be voted on by the board. There is a presumption that shifts the burden to prove there was no conflict of interest over to the director or officer if any of these certain things occur without that 14-day disclosure to the members before that vote is taken. So this is new in the statute, this rebuttable presumption, which means that the burden normally would be on someone who is raising the conflict to prove that there was a conflict. Now, if any of these things exist, it is now the director or officer's burden to prove there was not a conflict. So you're proving a negative, which is not an easy thing to do. That's why rebuttable presumptions exist, because it's basically the law saying, listen, you're really going to need to prove to us that you're right here, and we have no problem shifting this burden to you if the other side can show X. That's what we're talking about here. Fraudulent voting activities are defined as willfully and falsely swearing to or procuring someone else to swear to an oath or affirmation and arising regarding voting rights. Basically, a false statement regarding voting rights that is sworn to, perpetrating or attempting to perpetrate or aiding in perpetration of fraud in connection of a vote cast, to be cast, or attempted to be cast. So that's past, present, future. We've got preventing a member from voting or preventing a member from voting as they intended by fraudulently changing or attempting to change a ballot envelope, vote, or voting certificate. Sometimes we'll see this by members that are intentionally casting a ballot for someone that they know is going to cast their own ballot, so that it calls into question which one of those is valid and you have to strike out both. That is considered voter fraud and is fraudulent voting activity, which is a misdemeanor of the first degree. So you are committing a crime if you commit voter fraud in an HOA at this point. All of these things as well, menacing, basically threatening someone or bribing them in order to vote in a specific way or influence them as to how they should vote. That doesn't mean you can't go out and say, hey, we think this is a good idea or a bad idea because X. It's, this is what will happen to you. And it's not, this is what will happen to you, we will have problems in our community. It's, this is what will happen to you, I will break your kneecaps. Doesn't necessarily need to go to that extent, but it's kind of a smell test here. You'll know it when you smell it, if it's true problem or not. Consult with your attorney if you're not sure whether it's a problem or not, because you want to make sure before you make these accusations that you are actually consulting with counsel and can rely on advice of counsel as part of your business judgment. Promising anything of value or giving something of value with the intent to basically buy a vote, which doesn't count as food that's to be consumed at the election rally or meeting, or any item of nominal value used as an election advertisement, including a campaign message designed to be worn by a member. So if you give out your pen, that is of nominal value, unless it is a Mont Blanc that happens to have your name on it. Using or threatening to use direct or indirect force. So again, we talked about threatening people. Those are now things, just to recap, that will qualify as a misdemeanor of the first degree because they are election fraud or election tampering. For some of them is more accurate. Fines, what was clarified here is that rather than a lot of attorneys would say, you just need to send out a notice that these people have an opportunity to have a fining committee hearing. I was never one of those. I always said that the statute was fairly clear that you needed to actually hold the fining committee hearing, but the legislature saw fit to clarify that, so maybe it wasn't as clear as I thought. But now it is. As of July 1st, 2023, it was abundantly clear that the fining process in an HOA is you send a notice of a board meeting, you hold the board meeting, the board decides on a fine, and then you provide 14 days notice and a hearing, not an opportunity for a hearing, before a separate fining committee. The fining committee decides whether to levy the fine or not, and then if so, a notice goes out to the owner. The hearing is mandatory. The notice must include now a description of the alleged violation, the specific action that's required to cure the violation, and the date and location of the hearing. So before it was, you're going to be held in front of a fining committee hearing. Now it's, here's what you did wrong. Here's why it's wrong. Here's what you got to do to fix it. And here's when you have to fix it before, in order for us to maybe consider not holding this hearing, which we will hold unless we decide that the violation's been cured sooner. They have the right to attend, the owner has the right to attend the hearing by phone or other electronic means, meaning that if you're able to offer Zoom or a phone hearing, that's sufficient. After the hearing, that committee provides written notice to the owner as to whether the fine was actually levied or not. And that committee's actions need to be approved by a majority of the committee's members. Some people were arguing for some reason that it had to be a unanimous decision to fine. In my opinion, it's always been a majority of that committee that made the decisions on behalf of the committee, just like every other committee in all of Florida. All right, insurance reform. And the reform is insurance costs go up. Congratulations, in case you haven't already seen that happening. So the statute of limitations for negligence was reduced from 4 years to 2 last year. That's why you saw a flood of over 10,000 personal injury cases filed within a matter of a week when this was going through, because people tended to make the effort to try and settle these cases. And there were independent studies that needed to be performed. People needed to do either, if it's personal injury, they needed to go to doctors and check out what the actual problem was. Apparently, the legislature in its infinite wisdom has decided that 2 years is enough time to do all those studies, get checked out, make a determination of what your damages are, and have the demand sent out, responded to, possibly settled, insurance getting involved, and then filing your lawsuit if you need to. I don't necessarily agree, but this did significantly change the way that personal injury attorneys and property defense attorneys have begun practicing regarding negligence. This does impact community associations because a lot of times if there's damage to the common areas or common elements that damages someone's property, the argument is, well, you were negligent in maintaining that particular item that caused the leak, caused the damage, whatever it may be. So just understand we're now down from 4 years to 2 when it comes to filing a lawsuit founded on negligence. Additional changes to liability laws: any party to a negligence action that isn't medical malpractice that's more than 50% at fault, and this is a determination that's made by the judge or jury, usually the jury, doesn't recover any damages at all. So the way that it used to be is if the association is being sued and the association was found 25% at fault for the damages that occurred, the owner was 75% at fault. Well, you know what? The owner would only get 25% of their damages. Now, if the party is more than 50% at fault for their own harm, they don't recover any damages. So that might be good for the association, because if it's the owner's fault and they're suing the association, the association doesn't have to pay anything. But it does impact personal injury cases and certain other types of cases. We've got an example here. I'm not going to go into detail and go through the example because we just don't have time, but I do think it's something worth considering. Here, what we're saying in red is if the plaintiff's more than half at fault for their own damages, meaning the defendant who is being sued is less than half responsible for the plaintiff's damages, the plaintiff doesn't recover anything anymore. Negligent security, the law changed a little bit here as well. The trier of fact in a negligent security case must consider the fault of all people who contributed to the injury, not just the defendant. The bill also creates a presumption against negligent security. Hint, hint, here's what your association might want to consider doing. If you've got these items that are more specifically described in the statute in your community on the property, So basically, it's a camera system at points of entry and exit, recordings held for at least 30 days. I know a lot of these are 14 days. You might want to consider spending the extra money to up that to 30. A controlled lighting system in the parking lot, the specifics of what that lighting system needs to entail are in the statute, and in the walkways, laundry rooms, common areas, and porches, if you have any. Lock gates with key or fob access along pool fence areas, meaning you just can't walk into the pool area willy-nilly. These are just things that allegedly will protect your members, your residents, your visitors, your invitees a little bit better. The statute also requires the following items, which the community might or might not even have authority to control. 1-inch deadbolt in each dwelling unit entry door. If you're in an HOA, you may not have any control over that. If you're in a condo, you may need to change this may be a material alteration that requires a member vote. Locking device on each window. Again, you may not be the one that maintains all of these windows, so you might not have the ability to do this to the windows, exterior sliding doors, other doors not used for community purposes. Usually that's going to mean the ones that are pertinent to each unit. You might not have control over that at all. A peephole door viewer on each dwelling unit entry door that doesn't have a window next to or in the door, meaning you have just the peephole, but not the big window above that people can see into the unit from. For purposes of establishing the presumption against liability, the burden's on the owner or principal operator, meaning the association, to demonstrate that they've substantially complied with these measures. So if you've done these things, make sure that you've got records showing that you've done them. You might want to consult with a security company that tends to work with community associations and or apartment complexes, because both are going to be responsible for this type of thing. Hotels may or may not be helpful. Construction defect reform is another big one. This took effect April 13th of last year. And essentially what we're looking at is this bill shortens the time to bring a hidden construction defect claim. It used to be 20 years. Then it went down to 10 years to bring that claim a couple years ago. It's now 7 years, effective July 31st of this year. So when you're bringing that lawsuit founded on the design, planning, or construction of basically the community, and frankly, also as to each individual lot, the owner's residence that was constructed, they also will have 7 years. It's measured from the certificate of occupancy, and it must be brought within 4 years. So you've got very little time now as compared to before to actually raise this construction defect issue. That's part of the reason I mentioned earlier. My suggestion is every community after turnover should get an engineer in there and check and make sure that there are no problems that you don't know about. That's what these hidden defects are all about. If you've got issues with this in your community, we do have someone in-house that can assist you. I trust in him inherently, and he does a fantastic job. His name's Jeff Green. So if you don't want to reach out to me, feel free to reach out to him if you've got these issues going on. The lawsuit now needs to be filed from the earlier date of the issuance of a temporary certificate of occupancy or a certificate of completion rather than the CO. So this is an earlier date in addition to a shorter time frame. So just understand, you've got next to no time to actually file this lawsuit by the time the turnover occurs. So you got to move on it fast. The statute of repose is a hard deadline to file this lawsuit. As to latent defects, so you know what? I was going to go through this, but it's kind of what I just explained, where you've got a timeline to file your lawsuit. So I do suggest reading through this slide, but we're going to save some time because we're at 3:20 and I've got almost 20 slides left. More changes. This one is effective, or was effective, as of July 1st, 2023. Once a construction permit's issued, a local enforcing agency can only require substantive changes to the plans or specs, meaning they can only make changes and say, you know what, we wanted you to do this, but we didn't tell you before. If it's required to comply with the Florida Building Code, the Florida Fire Prevention Code, the Life Safety Code, or local amendments to those items. So what we're saying is, if there is a construction permit issued, you stick with what's in the permit unless the permit would have violated any one of these codes. Okay. If the local enforcement agency made a mistake, that mistake's on them. If the changes are made, the agency needs to specify which non-compliant features exist to the permit holder in writing, meaning that it's not just, well, your permit's being taken away. We gave it to you, now we're taking it away because it actually didn't comply. The local enforcing agency needs to specify what they screwed up, is what it comes down to. The agency can be penalized for failure to provide that information in writing. And that's basically dollars, of course, that the government is already paying, and they're paying back to the government. So that's super helpful. Some of it may be damages that are paid to the individual or the company that requested the permit, but based on the statute, it's going back right back to the government. Specialty licenses. Local governments can no longer determine licensure requirements for these people. I don't know why the heck the DBPR wants us to include this, but just be aware of it. Take a look at it. Have fun. Drone delivery services is another one. I don't know why they want us to talk about, but you're more than welcome to review that. Case law update. So this is actually not outdated, but is not brand new anymore. But we talk about self-help versus the right to an injunction. So self-help is when you physically go onto a property and cure a violation that the owner is allowed to arise on their lot. Okay, that's literally, you didn't cut your grass for 6 months, so we're going to send a vendor out there to do it for you. And we're going to charge the cost of that to you as an assessment because our declaration says we're allowed to do that. Well, most communities in logic terms are not also going to go onto the property, even though they have the authority to do so, and repair or replace the lot's roof. You're not going to power wash the side of the residence and potentially break a window. You're not going to dig in and add screening material adjacent to the trash cans and risk cutting a utility line. Well, apparently, according to Florida's second DCA, that's not a good enough explanation, and it's too speculative that either that type of damage might come up, or frankly, we're in Florida. The speculation in this case was that the owner might come out of the property and shoot me in the face because I'm coming onto their property unannounced and uninvited. Now, the announcement should have happened. You should have sent a notice to the owner saying, we're going to do this on or after this date. But how many people actually check and care about their mail coming from the association? If they did, you would have a lot more people at your meetings and you'd have a lot more people responding to your demand letters. So this case essentially said, well, you know what? The association had the remedy available. This is the Moriello case. The association had the remedy available to actually go out and do it, go out and do this self-help. It wasn't mandatory in your governing documents, but because you had the authority to do it, you have what's called an adequate remedy at law. And that means that you can't get an injunction because one of the requirements of an injunction is that you don't have an adequate remedy at law. Meaning you shouldn't have filed your lawsuit for covenant enforcement. You should have just gone out and done the work. So in April 2022, this decision comes out, and I don't remember whether we put McConico in here. Yes, we did. Good. So this decision comes out, and most attorneys logically say, okay, but what about the risk that my vendor gets shot in the face and his family or her family and their company ends up suing the association? The member sues the association for PTSD after having shot this person. That is maybe a little bit literally fatalistic, but the reality is you're taking a huge risk going onto someone's property and doing this work for them. And logically, most community associations have taken that position since the case that came out, I believe, in 2012, that said, well, if the association can force place insurance, it should, instead of suing to force the owner to get the insurance. So Moriello extends that holding to, well, if you can do self-help and physically go onto a property and cure a violation, you need to do that. You can't seek an injunction. If the owner interferes with that, then maybe you can get your injunction, but not before you at least make the attempt. Now we've got McConico that goes even a step further and says, well, yeah, I know you might get shot. I know you might get injured. I know you might cause major damage to this property and this owner's property by going on and mowing the lawn, pulling the weeds, chemically treating the driveway. But you know what? That risk is too speculative until you get shot, until you end up tearing a utility line, until you cut a power line that shuts the power down throughout the community. So now McConico basically says, and this is the 6th DCA of Florida, the newly created DCA from last year, This basically says, well, I don't really care about that speculation. You need to at least try it out. And if you don't, you won't get your injunction. And the other side's going to get their attorney's fees and costs back. So what this case means to me is that associations that are choosing, their boards are choosing not to do self-help, but have the ability to do that in their declaration, should be pursuing an amendment to remove that self-help from the declaration. Another one I'm going to suggest you consider implementing that isn't part of this presentation, but is related. Have your declaration say that the owners or the individuals who cause a problem within the community, meaning that you're doing covenant enforcement, you're trying to get your injunction, you're trying to get the problem resolved by court order, the lot or unit that causes that legal work to be performed by failing and refusing to comply with the covenants of the association is personally responsible, and the unit or lot itself is responsible for that cost as an assessment. And regardless of whether a lawsuit's filed or not, so that if you don't have to go to the extent of filing a lawsuit, the owner is still obligated to pay those attorney's fees and costs. Most communities currently treat that as a cost of doing business. I'm trying to get it so that my clients, and I can't promise anyone else's clients, but our firm's clients at least, we're trying to make it so that those associations don't treat that as a cost of doing business. Their entire membership isn't responsible for something that was caused by just one person or one lot or one unit. And that individual eventually is held responsible for those charges. Now, the other thing that I'll get onto a soapbox just for a second, speaking of the charges being associated with just the unit or the lot that it pertains to, is the estoppel bill that is currently pending and is potentially going through the legislature and passing. Please, I beg you, reach out to your legislators and point out why the bill that is currently pending that says that the association should be responsible for all costs and expenses affiliated with estoppel certificates. This is the document that your closing agent asked for, so they know what's owed for assessments, etc., what violations are on the property, so that they can close a transaction regarding a particular lot, unit, or set of lots or units. That cost that the association manager charges, that the attorney charges, that currently the association is allowed to charge to the requestor of that document, the bill would make it so that you can no longer charge that and it just becomes an association expense. And we've got a client that currently has told us this will cost them $70,000 in the next year if that bill passes, because it's a cost that suddenly, instead of it being directed to the individual who's selling their lot and getting the hell out of Dodge, or is refinancing and having the benefit of the lender paying off all their debt to the association, instead of it being that that individual covers the cost of this estoppel certificate, this bill would say that it gets spread amongst everyone. So I know that we talked about this on the Castle webinar on the 17th. Check out their website, because there is a form letter and a list of people that you should be reaching out to about it. I just think it's
The link is in the chat for that seminar, Alan.
will only be hurtful. Jeff, I'm sorry. Did you have something to add?
Oh, sorry about that. Yeah, the link for that webinar is in the chat as we speak.
Perfect. Thank you. I appreciate that. So moving on to Senate Bills 2A and 2B, which went into effect in February 2023 and June 2023 in opposite order. I don't know why I did it that way. Assignment of benefits. This is another insurance issue, and it basically prohibits the assignment of any post-loss insurance benefit, basically allowing someone else to sue on your behalf and take action, or more likely inaction, which is the reason that this was changed, on your behalf under any residential property insurance policy or any commercial property insurance policy issued on or after January 1st, 2023. What this means for all practical purposes is that if the owner is going to raise a claim and file a lawsuit, the owner raises the claim and files the lawsuit, and more importantly, maintains control over how that lawsuit is handled, which you lose when you assign the benefits, which is literally the reason for the term. You're assigning your right to recover any of that to the insurance company that has paid you out of pocket and is trying to get the money back from the person or company that caused the problem, that caused you to have to go out and spend that money. So this legislation says if the policy is issued on or after January 1st, 2023, that assignment of benefits is either invalid or can't be included. Bad faith failure to settle actions against property insurers. So bad faith litigation is now much more difficult, meaning that if your insurance company rejects your claim for absolutely no reason, even though they should have covered it, it's now more difficult, to go back and sue them and say, you were supposed to cover this, guys. What are you doing here? It reduces the deadline for you to report that claim under the policy from 2 years to 1 for a new or reopened claim, and from 3 years to 18 months for supplemental claims, meaning you're adding on to an existing claim. So in other words, you have half the time to actually file a bad faith claim, which requires that you submit the claim, they deny the claim, which can take a couple months. You find an attorney to help you out with this, they send a demand, then you file your lawsuit, all within 1 year. Or 18 months if it's a supplemental claim. None of this is clean, none of it's easy, and I frankly think that 1 year is way too little time, but that's what your legislature has provided. And frankly, most of this insurance legislation that is included in our seminar today is the result, in my personal opinion, and not the firm's opinion, but my personal opinion, of frankly fraud by the insurance industry in telling the legislature that all these problems existed, which have since been completely disproven, and all this did was help the insurance industry make more money. So I don't like any of this, but attorney's fees and litigation under property insurance contracts, the one-way attorney's fee provisions are not applicable in a suit arising under a residential or commercial property insurance policy. What this means is that if you lose this type of claim, the insurer is now able to get an award of attorney's fees and costs against you, meaning that there is less of an incentive to actually bring a valid claim, and people that don't have a bunch of money lying around and are not inclined to file for bankruptcy protection after this claim is fails for whatever reason it may be, regardless of good faith or bad faith in filing the lawsuit in the first place, they will end up having to pay the insurer's fees. So that is another lovely change that went into place last year. The civil offer of judgment statute was reinstated, meaning that if you send an offer of judgment, it's basically a document that says, I think that my claim is worth X. If the actual judgment is way less than that, then you don't get your, it's basically a way of limiting attorney's fees. I'm not going to go into detail about it. Allows joint offers of judgment, joint offers of settlement in property insurance litigation contingent on acceptance of all joint offerees, meaning if you're making an offer, all of the offerees need to accept that potentially, rather than you being able to get out of your litigation. It removes the provisions regarding attorney's fees related to alternative procedures for resolution of disputed sinkhole insurance claims. Another benefit to the insurance industry. Arbitration, the insurer can include mandatory binding arbitration in its policies so that you don't get in front of a judge and a jury. The insurer can't require a policyholder to participate in that arbitration unless specific conditions are met, including that the insurer also offers policies that don't have that arbitration clause. There's nothing in here, surprisingly enough, that says that they really need to offer one or the other of these. But the insurer does need to provide an appropriate premium discount in exchange for the rights that you're giving up by agreeing to arbitration. In other words, they need to provide two different types of policies, and they need to have the arbitration inclusion policy at a much lower rate. Now, a premium discount doesn't mean much lower rate. I just think it should, because arbitration is inevitably going to provide less of an opportunity for a fair decision. Well, I say inevitably, maybe that's not fair, but there's less opportunity, in my opinion, for a fair decision as compared to a jury actually making a determination of who gets what. There's also, and I won't go through them in detail, prompt pay laws regarding property insurance claims. You're welcome to read through these. Again, we're required to include them, and I think that they're valuable, but I'm not going to go through them in detail. The local government emergency bridge loan program was also created to provide financial assistance to local governments that were impacted by Hurricanes Ian or Nicole. It's basically $50 million in non-recurring funds that are available for hurricane repairs. It transfers $650 million to the Emergency Preparedness and Response Fund to be used for responding to a declared state of emergency. I think that one's a good one, actually, because frankly, we're in Florida and we need something like that. There are additional hurricane-related bills that are in place right now being passed through the legislature. Just be aware they exist. Those were discussed briefly during the Castle Group webinar that I mentioned earlier that I did with Jeff Rembaum of our firm and with Castle Group's Craig. I really suggest that if you're interested in where this is headed versus where we now are following the 2023 legislative session, it might be beneficial to you. I know that there are probably going to be significant additional Rembaum's Roundup articles and probably a couple other webinars that we're going to do on the bills that are now passing through the legislature. But that's the one that we've got as of right now, and I'm in it. So I welcome you to take a look at it. That one is available, again, free on our website, just like all our other webinars from the past. Just understand, no credit available for the pre-recorded sessions. So that's all I've got, Jeff. If you want to push forward to the Q&A and deal with all of your typical circumstances regarding surveys, etc., I will leave it to you. And hopefully that was enough of a reprieve for you to recover a little bit of your voice thanks to your health conditions right now.
Well, thank you very much. I just I can give
Oh
Barry
man,
White
that
a run.
voice! Holy God, Jeff!
I can give Barry White a run for his money right now. Can't get enough of your love, baby. So, so folks, I'm going to place the link for the evaluation into the chat. Stop smiling. You're making me laugh.
It's hard. Can't do it.
On topic.
We've got a bunch of Q&A. We've got 7 questions from just the first person, so we'll have probably enough to keep us busy. I'm going to actually bounce back and forth between Liliana's questions and all the others just to make sure that as many people as possible get at least one question answered. So
and remember too, we have about 20 minutes left, 15 to 20 minutes left.
Right.
Someone has to get out of here for an association meeting as soon as we're done. So if the questions pile up, we're not going to get to all of them, but you can put them in the evaluation. Alan, go ahead, baby.
All right, thank you. Master association's an HOA, not a condo, and is responsible for common elements, roof, pool deck, etc. Is it exempt from this law? Yes, if the master association is an HOA, the master association is not responsible for legal obligations of a condominium. So I presume this refers to the SIRS and MERS that I talked about for about the first 45 minutes of the presentation. That does not apply to an HOA that's subject to Chapter 720. So just make sure, by the way, you might want to ask your actual counsel whether or not this master association actually is an HOA or if it might be subject to Chapter 718. But if the answer is it's subject to Chapter 720, absolutely not required for an HOA. Marley asked, did I understand correctly? We can't prohibit someone from adding synthetic grass on their property. No, you did not get that completely correct. You can't enforce it if it's not visible from the frontage of the lot. And this is, I presume, in an HOA, this doesn't apply to condos. But in an HOA, you can't enforce a restriction that says you can't have synthetic grass if it's installed in a location that is not visible from the frontage of the lot or any adjacent lot. Now, if using synthetic grass rather than real grass ends up resulting, like I said earlier, in some kind of drainage issue that impacts the common elements, common areas, or another lot, that might be a separate violation that the association can enforce. Now, moving forward, Liliana's question number 2, can the mailing address that someone provides be international, and is the association obligated to mail internationally? Yeah, there's no restriction on that as to whether international is allowed or not. Anonymous, why are you stating that the board would be sued individually for breach of fiduciary duty? They would have coverage on the association's D&O policy. This was anonymous attendee who apparently doesn't appear to agree with my opinion. Just understand, coverage under a D&O policy does not mean you don't get sued. It means you might have coverage under a policy. And if you have done something that is explicitly in violation of the statute, which requires that it be deemed an intentional violation of the statute under the statute itself, it might not be covered by a D&O policy. Likewise, it might not be covered by the indemnification provision of your governing documents if there is one. So I can understand the distinction here, but I don't think that the person asking the question understood the distinction between getting sued and winning. The director and officer can still be sued. The fact that it's covered by an insurance policy means that the attorney that defends you in that lawsuit is going to potentially be paid for by the insurance carrier, except as to the extent of your deductible. So hope that clears that issue up. Number 3, how's the owner supposed to give the email address for official notices if management doesn't give the option to give it for this reason? They can send you a letter. You should have a form that they can fill out to opt in. And if management doesn't have a method of accepting that, then frankly, have your attorney prepare a form that gets sent over to management, and the notices get sent in that manner going forward. Are elevators included in the CEUs if greater than $10,000? Anything that is structural, including elevators. So William, that's your answer, is a quick yes. Anything that's greater than $10,000 to repair or replace that is an asset of the association that doesn't get repaired every single year for that cost is going to be something that is generally included in the CEUs, because that is a little g category item. Kickbacks, manager, is that property manager? Yes, that's your community association manager. What if the property management company receives a vendor kickback but doesn't disclose it? There's legislation going in now that would, it's a bill that is pending right now that would make that a clearer violation of Florida law. Right now, I think it's probably a violation of the Florida Administrative Code, but to be candid with you, it's not something I've ever fortunately had to investigate. So I would anticipate that the Florida Administrative Code would provide the enforcement mechanism for that. If it doesn't, then you'll look at the statutes. Christy is the treasurer of a 39-unit 2-story condo association. Milestone inspection and CEUs do not apply because you are less than 3 stories. That was easy. Fraudulent voting activities, do they apply to condos? Change wasn't made this year, but some of them will still apply to a condo. So you'll want to look into the specific voter fraud that you're concerned with and get an opinion from your counsel, or frankly, just look at the statute. It's really clear in the statute what is now a violation and what is now voter fraud versus what isn't. Anonymous again, maybe different anonymous, I don't know. Election process verification. Can a candidate pass out buttons and pens with their name on it? Yes, because that would presumably have a nominal value. And now if it's a button that has $100 bill in cash affixed behind the button, or if it's like I said, like a Mont Blanc pen that costs $100, different story. I think if you limit it to $25, given the fact that that's the dollar figure for food that is set forth in the statute, you're most likely safe, but I certainly can't guarantee that. Is the manager allowed to attend the committee hearings? I presume this pertains to finding. The answer is yes. Explain an HOA's responsibility for security. I didn't understand. What I talked about is actually the way that the association can create a presumption that its security was sufficient under Florida law. So it's not necessarily that the association even automatically has a responsibility for security. Really, in general terms, the association's responsibility for security is to go ahead and, if they know of an issue, do what they can to resolve that issue with respect to security. So if they know there are break-ins in the community and they have the means to actually prevent those break-ins, they have to try and do something, in my opinion, to try and prevent them. If they have zero control whatsoever over those break-ins, other than, well, let's tell everyone to call the police if they see someone that looks suspicious, there may be nothing that the association can do. Last question for Liliana, and I hope you appreciate the 7 answers here. Estoppel fees in condos as well. Yes, that bill that I talked about would pertain to condos, HOAs, and co-ops, no longer being allowed to charge anything for estoppel fees. So that charge would still get charged to the association. It just wouldn't be collectible anymore. Lori asked a second question within the same one, but I bounced back. What did you say about the expense that someone creates by not following the covenants? Are we allowed to bill them? That depends on the covenants themselves. Usually what they're going to say as of now is that the association can recover its attorney's fees and costs incurred in enforcement if you prevail in a lawsuit. What I am suggesting is an amendment to that particular covenant that says that the association can recover its attorney's fees and costs incurred in enforcement directly as an assessment against the lot, regardless of whether a lawsuit is filed or not. So that you're collecting directly from the person that caused the problem, rather than trying to collect that and getting wiped out in bankruptcy right after you get your judgment. Official records inspections in condos is the max 2 people for review of records. Yes, as of now, it basically says you have the ability to have the member and their designated representative. It doesn't say that there's 8,000 people that can come to this inspection. And if 5 people request the exact same records, the association still has the ability to say, 1, your inspection is on this time and date, 2, your inspection is on this time and date, etc., as long as all of those are within 10 business days after each request was received. Yet it is 7:20, so it is actually a loophole to get away. I don't know, Liliana, what that one referred to, but hopefully I answered the question when I went through the other ones you had. Richard, can an association, this is an HOA, raffle off a prize to owners who submit a membership meeting proxy? I've never seen it done. Candidly, I don't have a straight answer for this one, because you're basically, the way that I view that is you are explicitly telling someone, if you vote, I might give you something. So I would see that as potential voter fraud. Frankly, yes, I see the value there in trying to get as many people to vote as possible. I think you do better with using electronic voting that people might actually do, versus trying to buy something for someone who happens to submit a vote. I know that you're not buying it directly for them. I still think that that's an ethical concern, is the way that I'll phrase it. It's not necessarily a you can't do that, but more of a, well, I'm not so sure. And again, you got that smell test. If I don't think that it would be okay, maybe you really run it by your attorney and get a formal opinion. And frankly, I don't know where my opinion would go on that one personally. Are non-CEUs reserves and CEUs reserves allowed to be commingled in a single bank account? Nope, they must be separate. So now you're saying that an RV vote in an HOA parked in a driveway is at night is allowed to be there? Not even a little. What I'm saying is, if you can see it from the street, which you generally probably can if it's parked in the driveway, it's still enforceable. If you cannot see it, what the legislature, and one legislator in particular, was allegedly trying to accomplish is essentially, well, you know what? We don't want people to we don't want associations to have control of what I do in my backyard, what I install there, when no one else can see it. So it doesn't impact anyone other than me, which is why the legislature was phrased the way it was, and why some of those loopholes are still there. So I'm not saying an RV or a boat in an HOA that's parked in the driveway is no longer enforceable and is allowed to be there. I'm saying if you can't see that RV or boat from the frontage of the lot or an adjacent lot, then you can't enforce it. Now, I don't know of many people who park a boat just on its own on a property. Usually that's on a trailer, which means usually it's going to be higher than any bushes or any fence that's surrounding the lot, unless you live in one of the communities that's got, 2-3 acre lots. But if you're in I will call it a standard HOA, chances are you're going to be able to see that, and you're going to be able to take a picture of it, and you're going to be able to enforce that violation. Number 2 from Charles, regarding reserve funding, is the association required to include inflation increases, or can they take today's cost of a component and use that value to reserve for when the component will last another 10 years, and then maybe then cost $150, 150% of today's estimate? So basically, are you obligated to adjust for inflation? And the answer is no, but I'd recommend it, because otherwise you are probably far underfunding, because look at what inflation looks like as a percentage every year. Can a 2-story condo membership still vote to waive funding reserves? Yes, because none of these restrictions apply to them. Oscar, can you please elaborate one more time, or write down what you'd like the CAM to do in conjunction with the board regarding self-help? I'm suggesting that you amend the actual declaration to limit the self-help that can be performed to the things the association is actually willing to do. So I'm saying if you're not willing to go out and go on someone's property and do the work for them, take that out altogether. Don't have self-help, amend it out of the declaration. David, did we go over the CTA? And in my opinion, is it intrusive enough for condo board members to be concerned about revealing personal information? Check out, we did discuss that. I didn't discuss it today because it's not something that was in place last year, but it is something that we talked about during the Castle webinar that Jeff provided the link for. It's one of the first things we discussed, so you wouldn't even have to get that deep into the webinar. And for those who don't know, we're talking about the Corporate Transparency Act here. I do think it's intrusive. I think it's ridiculous that condo and HOA board members even need to complete this information. Fortunately, we've got enough time where we're still suggesting that you wait until the last quarter of 2024 because the requirement doesn't kick in until December 31st of this year to actually have the information submitted. We're suggesting hold off because there are a lot of people, not just in Florida or just in our firm, that are pushing to have it so that this law that pertains to fraudulent funding and terrorist funding doesn't apply to condos and HOAs in Florida. Wanda, doesn't the association have to vote for email-only notices? Nope. The members just need to authorize it individually. So it's not the entire association voting. It's just the individual opting in. Now, if the member did not opt in, the association still needs to send some notices via paper. So just understand it's only those members that opted in that you're even remotely changing your procedure for. Marie, can a board member send emails to endorse candidates in a co-op? Again, that's one of those, well, you know, to some extent, we're talking about the smell test. I think it's okay, but it has the political ramifications that you might not want. You might want to have one of the other members send that out instead of one of the current directors. Please discuss selective enforcement of ACC guidelines. This is essentially, and this is for John, selective enforcement is really when you are enforcing your covenants and your guidelines in one way for one person and another way for another person, or you're choosing not to enforce those guidelines against one lot and you are enforcing them against another lot. So that is a potential defense to enforcement efforts by the association. There are about 10 requirements that I've located in Florida case law, and one of them that applies to this type of claim is that you were led to believe that it would be okay to do what you're doing. Now, one of the ways around that belief is for the association to say, we acknowledge that some people have gotten away with this in the past. We're going to send out a letter to everyone in the community that says, we're not allowing this going forward. So if you think that you're grandfathered, you need to register this violation with us. We'll allow it to stay. But going forward, we intend to enforce this against everyone across the board equally. Christopher, it is often difficult to make the distinction between voting fraud and voting committee incompetence. I agree. The good news is that the statutes that we talked about today are frankly some of the things that you can look at to see what is considered voter fraud versus the people that are controlling the voting being incompetent. Again, I'll mention that an electronic voting platform is going to be automated and automatic and easy for you. It's something that I'd suggest your community consider. Some of the electronic voting companies will actually almost ensure that you are making up dollar for what you are already spending by mailing these notices to the members. So you may not even be spending more by having it operate this way, and you may not need to worry about that voting committee incompetence that's referenced in Christopher's message. David, thanks for the kind words. Two-story building must do reserve study. Jose, I disagree. I don't know if that was a question or a statement, but if it was a statement, I don't agree. Two-story building should do a reserve study to know what reserves they need, but there's no mandatory reserve studies that need to be done. Deborah, to whom do we write to express disfavor with the proposed estoppel law? Thank you so much for that. Deborah, you want to go to Castle Management's website, Castle Group. They have a letter and a list of people that you want to send out. And I'm not necessarily advocating for one management firm over another. I just happen to know they have it on their website because it was something that was discussed during the webinar that Jeff Rembaum and I did with them about 2 weeks ago. So thank you, Deborah. I really hope everyone will take that to heart. Michael, is there a time extension for a condo to complete its CEUs, or is it still by 12/31? That's going to be 12/31 unless you are doing it in conjunction with your milestone inspection report. So Liliana says master condo. I believe that was a question earlier about a master condo versus an HOA. If you are in a master condo, then the master condo may need that structural integrity reserve study, I believe was the question, versus not needing it because it's not a condo. So I hope that clarifies. Two-story building in Miami-Dade or Broward, square footage doesn't matter. Gudrun, the bottom line is the fact that it's two-story means it's not subject to these requirements, but it is going to be subject to local building requirements. Two-story building, Jose asked the same question, still no. Liliana, master HOAs governing. Okay, there's just a lot here, Liliana. I'm sorry, we went through 7 questions plus 1. Can't really go through all of them because we're down to 2 minutes. Susie, if management company buys burgers for an association social costing less than $25 a person, is that legal? Yes, that's less than $25 a person. In my opinion, you're probably fine. Bonnie Hurt, good to hear from you. Can an HOA certified request for info ask for the info to be emailed? Not necessarily, but frankly, I don't know why you would want to avoid that because it makes life easier for everyone. And Jeff, go ahead.
Hey, the link that we're looking for from the Castle website, is it the Corporate Transparency Act filing link?
The Castle link that I was looking for was the CTA email link. But I appreciate, I know the first thing you shared was the link to, I believe, the actual webinar video. There was also one on Castle's website.
I put the link into the chat. I think that's it.
Let's take a look.
To the
So that's a link to the actual website to register.
Okay.
So that might help. Yes.
Okay.
I'm sorry, I mixed up the two. The Castle link that I was referring to was actually the one about the estoppel bill. So that was my mistake. You know what? When you answer 45 questions in a matter of 20 minutes, you get a little scrambled. I apologize. All right. Well, Cindy is asking about the estoppel bill again. Castle Group. Wanda, thank you. Cheryl, thank you. Cindy, thank you. And Christopher, thank you. Miami-Dade and Broward do have stricter requirements, Gudrun. And you know what? We've got 4 left. I'm going to go ahead and answer them. But if you need to go through the information, because technically we're at the end of our allotted time. I know it was an hour and a half for the actual presentation, half an hour for Q&A. Unless you want me to just run through these in the next 2-3 minutes. It's up to you, Jeff.
Yeah, do the last 4. If any more come in, we're going to have to skip them.
Okay. Yeah, I'll just go through the ones that are in now. Actually, if you can shut that down.
If I shut it down, they'll disappear.
You're right. Okay. Then I will answer Bonita last. That's all. Right. Liliana, master HOAs govern buildings are subject to 720, but they're in charge with structural elements. It seems fair that they're not protected. Well, they might not be protected by the law, but they can still be protected by the board. So the bottom line is there's nothing that says you can't have a structural integrity reserve study, even though you don't have a legal obligation to do it because you're in an HOA. Natalie, is pressure cleaning part of the painting, and are funds in a reserve allowed to be used if the paint will not be done? If the paint's not going to be done, I just don't see that as part of the painting unless it's going to extend the life of the paint, which pressure washing, unless you're dealing with mildew or something like that, generally won't extend the life and actually help that reserve component. So that's one I would suggest just run it by your attorney and get a formal opinion so that you're protected if you use the funds for something that someone perceives as being outside of what you're supposed to be using those funds for. That way you've got protection of advice of counsel and your business judgment. If the legislature changed the statute, do we need to bother changing our docs to match? Yes, if you want to. And the reason for that is the legislature changed the statute. They can do the same damn thing next year. So if you want a change to apply across the board in your community, Susie, my recommendation is to try and adopt an amendment so that that applies potentially forever. Bonita is going to be the last one. Thank you to all who added that it was a good seminar. I like to think so. Is it proper for a management company to funnel association money through their bank account? In other words, they have the owners write their maintenance fees check directly to them. They pay themselves and then send the remaining funds to the association bank. I don't have a huge problem with that as long as it's what's in the management contract. Frankly, that's what our law firm does too. If we have an account in collection, someone sends a payment, we normally will apply that first to our attorney's fees and costs and then send what's left to the association. We're not taking association money, and the management firm should not be taking association funds. But chances are those management charges are something that under Florida law actually get the payment gets applied to them before any funds get applied to the underlying interest, late fees, assessments, etc. Actually, it would be interest, late fees, then management charges, attorney's fees and costs, and then finally to the assessment. So bottom line, I don't have a huge problem with it. Not necessarily ideal for the association to have that slight delay in payment, but it probably enables the management firm to be able to collect the payments on your behalf rather than having to have complete control over the association accounts. And now I'm done with the Q&A. Jeff, I'm going to go ahead and do my part because I do have to head out, but I really appreciate everyone that stuck around. We still have over 150 people here after 2 hours. I know this was grueling for everyone. I hope you enjoyed it at least a little. I hope you all got a lot out of it. I welcome everyone that's still here and everyone that's been here, and frankly, everyone that watches this later, to reach out to me at as@kbrlegal.com. If there are any questions whatsoever regarding the presentation, if you need an attorney and you don't have one, if you're not happy with your attorney, or if you just want someone who's going to give you a second opinion and not charge you an arm and a leg, we're happy to participate in helping out your community. So give me a call if you don't have an attorney or you need one. And frankly, even if you just have questions that you need some education on a topic you don't know enough about. So I thank everyone for being here today, Jeff, especially given your physical condition, Barry White style. I really appreciate your help as always, and look forward to the next one.